Law of agency: when a person delegates authority to someone to act on his behalf, an agency relationship has been created. Agency relationships fall within the body of law called law of agency. There are two types of law that society looks to for guidance regarding agency relationships: common law and statutory law. Common law, sometimes referred to as unwritten law, is law based on usage, general acceptance, and custom. It is judge-made law manifested in decrees and judgments of the courts. Case law. Common law originated in England and was later incorporated into the U.S. legal system. Under the English common law, servants owed absolute loyalty to their masters. This absolute loyalty is one of the fundamental principles of the agency relationship. Agency law derives from common law. Statutory law is written statutes enacted by the Florida legislature. Chapters 455 and 475 are two Florida statutes enacted by the Florida legislature pertaining to license law. Brokerage relationships in Florida. Historically, there has been confusion among buyers and sellers regarding what role that real estate licensees have in real estate negotiations. Sellers assumed that real estate licensees represented their interests because sellers traditionally paid the commission. However, the payment of commission or the promise of compensation alone is not what determines whether a brokerage relationship exists. A brokerage relationship can be accidentally, inadvertently created by a licensee's actions and words. For example, referring to a prospective purchaser as my buyer or my client may imply that the licensee is representing the buyer when in actuality the brokerage is representing the seller. Because of this confusion, the Florida legislature passed the Brokerage Relationship Disclosure Act. The Brokerage Relationship Disclosure Act is intended to inform and educate the public regarding the types of authority, brokerage relationships, that can be granted to a broker and the duties brokers have in each type of brokerage relationship. Brokerage relationship options. Licensees have three basic options in all real estate transactions concerning the role the real estate brokerage firm will assume for buyers and sellers. The parties may agree that the brokerage firm will not represent the buyer or the seller at all. This situation is called a no-brokerage relationship. The brokerage firm simply facilitates the transaction. The brokerage firm may work as a single agent of either the buyer or the seller, but not for both buyer and seller in the same transaction. The brokerage firm may work as a transaction broker for the buyer, the seller, or both. In Florida, a real estate licensee may enter into a brokerage relationship either as a transaction broker or as a single agent with prospective buyers and sellers. Alternatively, the customer may desire not to be represented in any capacity by the brokerage firm. For example, property owners who have found buyers for their own homes, for sale by owners, also called FSBOs, may want a knowledgeable real estate firm to handle the paperwork regarding the transaction. However, a FSBO seller may not need or desire the broker to represent or negotiate on the seller's behalf. In such cases, FSBOs may elect non-representation, also called a no-brokerage relationship with a brokerage firm. The appropriate type of brokerage relationship is determined by the broker. Some brokerage firms choose to operate as transaction brokers exclusively or only as single agents for buyers. Dual agency. It is illegal in Florida for a real estate licensee to operate as a dual agent. Dual agency occurs when a brokerage firm represents as a fiduciary both the prospective buyer and the prospective seller in the same real estate transaction. When a broker represents a buyer or a seller as a fiduciary, the broker is in a relationship of trust and confidence between the broker as agent and the seller as principal or the buyer as principal. A fiduciary relationship is created when a real estate broker accepts employment as a single agent of the seller or the buyer. In an agency relationship, the broker owes fiduciary duties to the principal. Florida real estate license law prohibits a broker from creating a fiduciary relationship with both the buyer and the seller in the same transaction. Residential transactions. Chapter 475 mandates certain duties and obligations in each type of brokerage relationship. These duties and obligations apply to all real estate transactions. However, written disclosures are required only when dealing in residential real estate transactions. Section 475.278. 5. Defines a residential sale as the sale of improved residential property of 4 or fewer units. The sale of unimproved residential property intended for use as 4 or fewer units, or the sale of agricultural property of 10 or fewer acres. Furthermore, the disclosure requirements do not apply to non-residential transactions, the rental or leasing of real property, unless an option to purchase all or a portion of the property improved with 4 or fewer residential units is given. Auctions, appraisals, and dispositions of any interest in business enterprises or business opportunities, except for property with 4 or fewer residential units. Note: licensees are not required to give customers a written disclosure when a transaction broker relationship is chosen. See also transaction brokerage later in this unit. Written disclosure requirements for residential transactions. When a brokerage company works with a buyer or a seller in a relationship other than as a transaction broker, the duties of the chosen relationship must be fully described and disclosed in writing to a buyer or the seller. The written disclosure may be either a separate and distinct disclosure document, or the disclosure may be included as part of another document, such as a listing agreement or buyer-broker agreement. If the disclosure document is incorporated into a listing or buyer-broker agreement, a signature line must be inserted immediately following the disclosure information. It is not sufficient to only have a signature line at the bottom of the listing or buyer-broker agreement. If a customer or a principal desires to proceed with a relationship but refuses to sign or initial the disclosure document, the licensee should include a copy of the disclosure in the file with a note indicating the date the disclosure was presented and that the buyer or the seller refused to sign the document. When incorporated into other documents, the required disclosure notice must be of the same size as, or larger type than, other provisions of the document and must be conspicuous in its placement to advise customers, or principals in a single agent relationship, of the brokerage duties. The first sentence must be printed in uppercase and bold type. The list of duties must be presented on the disclosure in the same order as listed in the statute. The disclosure notice may include information concerning the real estate brokerage, such as the company name and logo, address, phone number, email address, and so forth. Timing of brokerage disclosure. Non-representation. The no brokerage relationship notice must be disclosed in writing before the showing of property. Single agent. The single agent disclosure must be made before, or at the time of, entering into a listing agreement or an agreement for representation, or before the showing of property, whichever occurs first. Transaction broker. Under Florida law, it is presumed that licensees are operating as transaction brokers unless another brokerage relationship is established. A written transaction broker disclosure notice is not required to be given to the buyer or the seller. Record-keeping requirements. Brokers must retain all written brokerage relationship disclosure documents for 5 years for all residential transactions that result in a written contract to purchase and sell real property, and all non-residential transactions that use designated sales associates. This requirement includes files of properties that may have failed to close. If a transaction fails to close, the licensee should retain the brokerage relationship disclosure documents with the purchase and sale contract, escrow documentation, and other documents associated with the property, and place them in the dead, fail to close file. The documents may be stored in a digitized format. The Commission may discipline a licensee for failure to abide by any provision in Section 475.278 FS, including the duties owed to customers and principals, disclosure requirements, and record-keeping requirements set forth in law. Exceptions to disclosure requirements. Certain interactions a licensee has with buyers and sellers do not constitute a brokerage relationship. These situations are described in the real estate license law. When a licensee has an encounter with a buyer or a seller under these specific situations, the licensee is not required to give a prospective buyer or a prospective seller a disclosure notice. The 6 situations that do not create a brokerage relationship are as follows. When the licensee knows that a single agent or a transaction broker represents a prospective seller or buyer at a bona fide open house or model home showing that does not involve eliciting confidential information, the execution of a contractual offer or an agreement for representation, or negotiations concerning price, terms, or conditions of potential sale during unanticipated casual encounters between a licensee and a prospective seller or a prospective buyer that do not involve eliciting confidential information, the execution of a contractual offer or an agreement for representation, or negotiations concerning price, terms, or conditions of a potential sale when responding to general factual questions from a prospective seller or a prospective buyer concerning properties that have been advertised for sale. Situations in which a licensee's communications with the prospective buyer or seller are limited to providing either written or oral communication that is general, factual information about the qualifications, background, and services of the licensee or the licensee's brokerage firm. When an owner is selling new residential units built by the owner and the circumstances or setting should reasonably inform the potential buyer that the owner's employee or single agent is acting on behalf of the owner, whether because of the location of the sales office or because of office signage or placards or identification badges worn by the owner's employee or single agent. If, during any of the situations described above, a member of the public begins to provide confidential information or begins to negotiate concerning price, terms, and so forth, the licensee would at that point present the person with the appropriate disclosure notice, depending on the circumstances and desire of the parties. No brokerage relationship, non-representation. The seller, or the buyer, can choose not to be represented by a real estate broker. In such a situation, the broker would simply facilitate the sale or the purchase of real property without entering into either a single agent relationship or transaction broker relationship. A broker working in a no brokerage relationship, non-representation capacity with the seller can enter into a listing agreement with that seller and be paid a commission. Similarly, a brokerage firm working in a no brokerage relationship, non-representation capacity can work with a buyer. Florida law does not require that prospective buyers and sellers be represented. Prospective buyers and sellers in a no brokerage relationship are called customers. Chapter 475 defines customer to mean a member of the public who is or may be a buyer or a seller of real property and may or may not be represented by a real estate licensee in an authorized brokerage relationship. No brokerage relationship duties. A real estate licensee working in a non-representation capacity with a buyer or a seller has the following 3 duties. Account for all funds. Brokers must account for all funds entrusted to them with regard to a real estate transaction. Such holdings are considered trust funds or escrow funds. Money and valuables entrusted to a broker must be kept separate from the broker's funds. The broker is not entitled to any trust or escrow funds until the transaction is concluded at a title closing. Brokers are required to keep complete records of all transactions and funds, as well as to make available to the Department of Business and Professional Regulation, DBPR, such books, accounts, and records as will enable the DBPR to determine whether the broker is in compliance with Chapter 475. Disclose all known facts that materially affect the value of residential real property and are not readily observable to the buyer. Licensees have a duty to disclose to buyers all known facts that materially affect the value of residential property. For example, a licensee is obligated to inform the buyer if there are cracks in the tile floor under the wall. 2. Wall carpeting caused by a settling foundation. Questions sometimes arise regarding whether certain information concerning the seller or previous occupants of a property must be disclosed to prospective buyers. Federal Fair Housing Law and the Florida statutes specifically mandate that the fact that an occupant of real property is infected or has been infected with human immunodeficiency virus, HIV, or diagnosed with acquired immune deficiency syndrome is not a material fact in a real estate transaction. This is personal medical information and must not be disclosed without prior authorization. Furthermore, Florida statute mandates that a property's past status, or suspicion of such, as the site of a homicide, suicide, or death is not a material fact that must be disclosed in a real estate transaction. A cause of action will not arise against a property owner or a real estate licensee for failure to disclose any of the information or events listed here. Deal honestly and fairly. Licensees owe a duty of good faith and honesty to customers. A broker's customers are entitled to rely on any material statement related to a real estate transaction that is made by a licensee. The 3 duties required in a no brokerage relationship are required of real estate licensees in all types of brokerage relationships. To help recall the 3 duties, use the memory crutch ADD. To remember, 3 duties required in all brokerage relationships. A. Account for all funds. D. Deal honestly and fairly. D. Disclose all known facts that affect value of residential property. No brokerage relationship notice. A. Written no brokerage relationship. Disclosure must be given to the customer before the showing of property. See no brokerage relationship disclosure form. Single agent relationship. A seller, or a buyer, may want to be represented by a real estate broker. In this case, the real estate broker is a single agent who represents the seller as a fiduciary in selling the home or the buyer in finding a home. The Florida Real Estate License Law defines a single agent as a broker who represents, as a fiduciary, the buyer or the seller, but not both, in the same transaction. In a single agent relationship, the seller, or the buyer, is the principal, or client, and the real estate broker is the agent. The term principal is used to mean the party with whom a real estate licensee has entered into a single agent relationship. Subagents are persons authorized to assist and represent the agent. A subagent has the same duties as the agent. A broker sales associates are general agents of the broker and subagents of the broker's principals. For example, in a single agent relationship, the broker is an agent of the principal. The broker sales associates and broker associates are subagents of the broker's principals. Sales associates and broker associates owe the same fiduciary obligations to the broker's principals as does their broker. Note that this is true regardless of whether the associates, for tax purposes, are employees or independent contractors of the broker. Single agent duties. A real estate licensee owes 9 duties to a buyer or a seller who engages the real estate brokerage as a single agent. The 9 duties apply to all real estate transactions, residential and otherwise, when the parties have agreed to a single agent relationship. The first 3 duties in the list are duties a licensee owes to buyers and sellers in all 3 brokerage relationships. Account for all funds. Disclose all known facts that materially affect the value of residential real property and are not readily observable to the buyer. Deal honestly and fairly. Confidentiality. Much of the information a broker gains while employed by the principal is confidential. An agent cannot reveal to a third party, without the principal's permission, personal or private information that might lessen the principal's bargaining position. For example, a licensee cannot tell a buyer that a seller is forced to sell owing to poor health or loss of a job without the principal's permission. Brokers cannot divulge confidential information learned during the course of the single agency even after the transaction is concluded and the agent-principal relationship is ended. A broker is never free to use confidential information to the disadvantage of or reveal any harmful or unfavorable information about a former principal. Obedience. An agent is obligated to act in good faith according to the principal's lawful instructions. The broker agent is at all times obligated to act in conformity with the principal's instructions as long as those instructions are legal and relevant to the contractual relationship. If a broker feels that carrying out the principal's legal directions will harm the principal, then the broker must promptly inform the principal of all known facts along with the broker's opinion. However, if the principal will not change the instructions, the broker must either carry them out or withdraw from the relationship. Brokers may not violate the law. For example, if a principal instructs a listing broker not to show the property or sell to a member of a particular minority or ethnic group, the broker cannot obey the principal's instructions because doing so would violate the law. In such an instance, the broker must inform the principal that to restrict certain groups of people from seeing or purchasing a listed property is a violation of the fair housing laws. Loyalty. The agent as fiduciary in a real estate transaction must avoid any situation that might breach the duty of undivided loyalty to the principal. The overriding rule is that brokers may not adopt an attitude that is adverse to the interests of the principal or act for themselves or some other person whose interests are contrary to those of the principal. Loyalty, faithfulness, requires brokers to always place a principal's interests above those of other people with whom the broker deals. Courts have ruled, case law, that for brokers to be loyal to their principals, they cannot exercise duties in such a manner as to profit themselves or anyone else at the expense of the principal. The duty of loyalty includes, for example, obtaining the most favorable price and terms for the principal, acting on behalf of the principal, not acting for parties with adverse interest in the same transaction, never concealing the identity of the purchaser to induce the principal to sell, disclosing to the principal if the agent becomes personally interested in the principal's property, and never advancing the agent's or another person's interest at the expense of the principal. Full disclosure. It is a broker agent's duty to keep the principal fully informed at all times of all the facts or information that might affect the transaction or the value of the property. An agent is obligated to disclose facts regarding a property's true worth. Agents may be held responsible for material facts they should have known and communicated to their principal but did not. Also, broker agents must inform their seller principals, for example, of the buyer's financial condition, the status of the earnest money deposit, or if a personal relationship exists between the agent and the buyer. All material facts must be revealed to the principal even if the disclosure of such facts might cause the transaction to fail. Full, fair, and prompt disclosure also includes notifying the principal if the broker is personally interested in buying the listed property. In such an event, The broker must clearly terminate the agent-principal relationship and inform the principal of all facts regarding the property that the broker has learned while in an agent's capacity. Otherwise, the broker could buy from the principal and subsequently sell at a higher price and keep the profit, overage, secret profit or secret commission. To do so could be construed as fraud, misrepresentation, concealment, and/or dishonest dealing and expose the broker to liability to both the seller and the buyer for the full amount of the secret profit. It might further give rise to disciplinary proceedings against the licensee. Use skill, care, and diligence. A broker's obligations extend beyond merely selling a listing or locating a suitable property for a buyer. Real estate brokers hold themselves out to the public as specially qualified by reason of experience, ability, and knowledge. If a broker's principal is a buyer, then the broker should attempt to obtain the property at the lowest price possible. If the broker's principal is a seller, then the broker should try to get the seller the most favorable price. This includes researching a property thoroughly to advise the seller of a reasonable listing price. Brokers should discuss with their principals any anticipated tax consequences and advise them to seek expert tax advice when appropriate. The duty of using skill, care, and diligence does not end with the signing of a contract. It continues via numerous services by the agent until the transaction is closed. An agent who does not perform with the required degree of skill, care, and diligence becomes liable to the principal for the damages the principal may have sustained and may be disciplined by the FREC. Present all offers and counter-offers in a timely manner, unless a party has previously directed the licensee otherwise in writing. The licensee must present all oral and written offers and counter-offers in a timely manner even if a valid contract exists. 4 of the duties listed apply only to a single agent relationship. To help recall the 4 duties unique to a single agency relationship, use the memory crutch called to remember 4 unique duties of a single agent. A single agent owes 9 duties to the principal. 4 of the duties apply only to single agent relationships. See confidentiality, obedience, and loyalty, deed disclosure, full. Single agent notice. The 9 duties apply to all real estate transactions, residential and otherwise, when the parties have agreed to a single agent relationship. A written single agent disclosure is required for residential transactions. The notice must be given to the principal before, or at the time of, entering into a listing agreement or an agreement for representation. See single agent disclosure form. Transaction broker relationship. Under Florida law, it is presumed that all licensees are operating as transaction brokers unless a single agent or no brokerage relationship is established in writing with the customer. Limited representation. A transaction broker is a broker who provides limited representation to a buyer, a seller, or both in a real estate transaction, but who does not represent either party in a fiduciary capacity or as a single agent. Transaction brokers provide a limited form of non-fiduciary representation to a buyer, a seller, or both in a real estate transaction. In this relationship, the seller, or the buyer, is considered to be a customer of the real estate broker and not a principal. In a transaction broker relationship, the buyer or the seller, customer, is not responsible for the acts of a licensee. See textbooks, fiduciary and non-fiduciary relationships. In a transaction broker relationship, the parties to a real estate transaction are giving up their rights to the undivided loyalty of a licensee. This aspect of limited representation allows a licensee to facilitate a real estate transaction by assisting both the buyer and the seller. However, a licensee will not work to represent one party to the detriment of the other party when acting as a transaction broker to both parties. Real estate licensees are no longer required to give customers a written transaction broker notice. However, licensees must still fulfill the duties of a transaction broker when that form of representation is selected. Transaction broker duties. A real estate licensee owes 7 duties to a buyer or a seller who engages the real estate brokerage as a transaction broker. The 7 duties apply to all real estate transactions, residential and otherwise, when the parties have agreed to a transaction broker relationship. Recall that the first 3 duties in the list are duties a licensee owes to buyers and sellers in all 3 brokerage relationships. The 4th and 5th duties listed here apply to both the transaction broker relationship and the single agent brokerage relationship. The last 2 duties listed are unique to the transaction broker relationship. See brokerage relationship duties. Account for all funds. Disclose all known facts that materially affect the value of residential real property and are not readily observable to the buyer. Deal honestly and fairly. Use skill, care, and diligence. The The broker, for example, must keep informed of current zoning and other developments that may affect the value of the property and must use diligence in facilitating the transaction. Present all offers and counter-offers in a timely manner. Exercise limited confidentiality, unless waived in writing by a party. This limited confidentiality will prevent disclosure that the seller will accept a price less than the asking or listed price, that the buyer will pay a price greater than the price submitted in a written offer, of the motivation of any party for selling or buying property, that a seller or a buyer will agree to financing terms other than those offered, or of any other information requested by a party to remain confidential. Perform any additional duties that are mutually agreed to with a party. A real estate licensee must be careful not to accept duties beyond the scope of limited representation. To do so might create an unintended fiduciary relationship with the customer. For example, a transaction broker may not promise complete allegiance to a customer because to do so could be interpreted by a court of law to have created a fiduciary relationship. Brokerage relationship duties. No requirement for written transaction broker notice under Florida law. It is presumed that real estate licensees are operating as transaction brokers unless another brokerage relationship is established. Therefore, there is no requirement to give a written transaction broker disclosure notice to the buyer, the seller, or both when operating in a transaction broker relationship transition to another relationship. A single agent relationship may be changed to a transaction broker relationship at any time during the relationship between the agent and principal, provided the agent first obtains the principal's written consent to the change in relationship. To gain the principal's written consent to a change in relationship, the buyer or the seller, or both, must sign the consent to transition to transaction broker notice set forth in Chapter 475. Note that this disclosure notice requires the buyer's or the seller's signature before the licensee may change from one brokerage relationship to another. If the principal refuses to sign the consent to transition notice, the broker must continue to act as a single agent. Example: assume that a brokerage firm represents seller Rebecca as a single agent. Buyer Mike enters the brokerage firm with the purpose of finding a home to purchase. Mike is not working with any other real estate company and indicates that he wants the real estate firm to represent him in the real estate negotiations and to work solely in his best interest. Therefore, Mike has indicated to the licensee that he desires single agent representation. The licensee must give Mike the single agent notice before entering into a buyer agency agreement or before showing Mike any property. Because Mike has entered into a single agent relationship with a brokerage firm, the sales associate cannot show Rebecca's home to the buyer. This is because a broker cannot be a single agent of the buyer and a single agent of the seller in the same transaction. This is true even if Rebecca and Mike use different sales associates within the same company because the single agent agreement is with a brokerage firm. If a real estate broker represents both parties in a transaction in a fiduciary capacity, an illegal dual agent relationship is created. Because the seller and the buyer have each entered into single agent relationships with the brokerage firm, they must both give written consent to change to transaction broker relationships in order for Mike to be shown Rebecca's home. This is the purpose of allowing a licensee to transition from one agency status to another. Consent to transition notice. The consent to transition to transaction broker notice includes wording regarding the principal's permission to allow the single agent to transition to a transaction broker. The notice also includes a list of the 7 duties that a transaction broker owes to the customer. These 7 duties were presented in detail earlier in this unit. See transaction broker relationship. The consent to transaction broker notice can either be a separate document or be included as part of another document. For example, in the listing agreement. See disclosure format earlier in this unit for information concerning the required format of the disclosure notice. See consent to transaction broker. A licensee may also transition from a transaction broker relationship to a single agent relationship. Furthermore, a licensee may transition from any one of the brokerage relationships to another relationship. However, there is no specific disclosure language provided in the Florida license law for these situations. The licensee will have to accomplish the transition in a manner sufficient to withstand civil challenge under the common law. Designated sales associates in a non-residential real estate transaction where the buyer and the seller each have assets of $1 million or more. The broker, at the request of the buyer and the seller, may designate 2 sales associates to act as single agents for the buyer and the seller in the same transaction. The 2 sales associates in such an arrangement are called designated sales associates. Note that in a residential transaction this would be an illegal dual agency. The broker serves as an advisor to each designated sales associate, not to the buyer or the seller. The broker serves as a neutral party helping to facilitate the process without giving guidance or representation to the parties in the transaction. The designated sales associates have the duties of a single agent. Designated sales associate disclosure: the buyer and the seller must sign a disclosure notice stating that their assets meet the $1 million threshold and requesting that the broker use the designated sales associate form of representation. The disclosure notice includes special language regarding confidential information and also lists the 9 duties of a single agent. Refer to designated sales associate. Brokers must retain brokerage relationship disclosure documents for 5 years for all non-residential transactions that use designated sales associates. Terminating a brokerage relationship: generally speaking, a transaction broker relationship or a single agent relationship is terminated when the objectives have been accomplished according to the terms of the contract that created the brokerage relationship and notice is given to the other party. A principal is justified in revoking a single agent relationship with a broker if the broker agent breaches any of the fiduciary duties. A brokerage relationship between a principal or a customer and a broker may be terminated for any of these reasons: fulfillment of the brokerage relationship's purpose, for example, finding a ready, willing, and able buyer, mutual agreement to terminate the brokerage relationship, expiration of the terms of the agreement, if no term is specified. The courts have ruled that a brokerage relationship may be terminated after a reasonable time. Broker renounces the single agent relationship by giving notice to the principal, or the broker renounces the transaction broker relationship by giving notice to the customer. Principal revokes a single agent relationship or the customer revokes a transaction broker relationship by giving notice. In this case, the principal or the customer may be liable for damages, such as advertising expenses, incurred by revoking the brokerage relationship before the termination date of the listing contract or exclusive buyer contract. Death of a seller's broker or the seller before the broker finds a ready, willing, and able buyer. Death of the buyer's broker or the buyer before the broker finds a suitable property for the buyer. Destruction of the property or condemnation by eminent domain. Bankruptcy of the principal or the customer.
Important summary, Unit 10.
Summary of important points. A person who delegates authority to another is the principal. A person who accepts the authority is the agent. An agent is authorized to represent and act for the principal. The agency relationship creates a fiduciary relationship with the principal. A fiduciary acts in a position of trust or confidence with the principal. In all real estate transactions, there are 3 options concerning the role the real estate brokerage firm will assume. 1. No brokerage relationship. 2. Single agent of either the buyer or the seller. And 3. Transaction broker for the buyer and or the seller. Licensees may not operate as dual agents. A dual agent is a broker who represents both the buyer and the seller as a fiduciary. The duties and obligations in each type of brokerage relationship apply to all real estate transactions. A residential sale is defined as the sale of improved residential property of 4 or fewer units. The sale of unimproved residential property intended for use as 4 or fewer units, or the sale of agricultural property of 10 or fewer acres. A written disclosure is required for residential sale transactions when a single agent relationship or a no brokerage relationship is chosen. The single agency disclosure must be made before, or at the time of, entering into a listing agreement or an agreement for representation, or before the showing of property, whichever occurs first. The no brokerage relationship disclosure must be made before the showing of property. License law mandates that a real estate broker working in a no brokerage relationship capacity has 3 duties. 1. Deal honest and fairly. 2. Disclose all known facts that materially affect the value of residential real property that are not readily observable to the buyer. And 3. Account for all funds entrusted to the licensee. FS 475 mandates that a real estate broker working as a single agent has 9 duties. 3 of the duties are also required in a no brokerage relationship. 4 of the duties apply exclusively to a broker working as a single agent. 1. Confidentiality. 2. Obedience. 3. Loyalty. And 4. Full disclosure. Under Florida law, it is presumed that all licensees are operating as transaction brokers unless another brokerage relationship is chosen. A transaction broker provides limited representation to a buyer, a seller, or both, but does not represent either in a fiduciary capacity or as a single agent. License law mandates that a real estate broker working as a transaction broker has the duties required in a no brokerage relationship plus 4 additional duties. 1. Use skill, care, and diligence. 2. Present all offers and counteroffers. 3. Exercise limited confidentiality. And 4. Perform additional duties that are mutually agreed to. A real estate broker may change from a single agent relationship to a transaction broker relationship only with the express written permission of the principal. The principal must sign or initial the consent to transition to transaction broker disclosure before the change can occur. Brokers must retain brokerage relationship disclosure documents for 5 years for all residential transactions that result in a written contract to purchase and sell real property and all non-residential transactions that utilize designated sales associates. In a non-residential transaction and wherein the buyer and the seller each have assets of $1 million or more, the broker, at the request of the buyer and the seller, may designate 2 sales associates to be designated sales associates. In such situations, one sales associate acts as a single agent for the buyer and the other sales associate acts as a single agent for the seller. The broker is not considered a dual agent but rather a neutral party advising the designated sales associates to help facilitate the process. The buyer and the seller must sign the designated sales associate disclosure listing the duties of a single agent and affirming that the buyer and the seller each have assets of at least $1 million.